John Paul Schuessler?
Here.
Okay, ready in that case?
Yes.
Yes. Okay.
Your Honor, may the plaintiff approach the bench?
Yes.
With this small note?
Yes.
Your Honor, I'm extremely nervous. I don't know what I'm doing here. I'm pro se. I understand that. I will abide by all rules and procedures. I was just handed a motion to strike at the last moment by the defendants. My goals for today were to provide a proof of genuine issues that reasonable minds could disagree on in response to their motion for summary judgment. I also would like to begin the discovery process, including authorization to access a custodial bank account and access to records from a doctor's office. I also would like to highlight what I would refer to as possible perjury in the defendant's affidavits. Those are my goals. And I would also like to add, both parties are pro se, but the defendant, Wesley Schuessler, has 16 years of legal experience, including a degree from the Alabama Law School, 6 years Judge Advocate General, 10 years private practice in Auburn, Alabama, and some other experience. So he's not quite pro se.
So what are you asking for us to do today?
Really, I just came to reply to the motion for summary judgment and prove that there are genuine issues that reasonable minds could disagree on. Also wanted to access to as part of the breach of fiduciary claim, access to those records that are under the Uniform Transfer to Minors Act. And then I would like to point out possible perjury in the affidavit of the defendant, Wesley Schuessler.
Okay, what's your name again?
Hi, I'm his father. That's my son, John. My name is Wesley Schuessler, and this is his stepmother, my wife, Jenny Schuessler.
Okay.
And he's filed 7 claims against us. 6 of them are outside of the statute of limitations. 2 of them I've already been sued on, and it was settled in the state of Alabama. We filed affidavits and documents, and he filed his 1.5-page memorandum, and the hearing is set for today on our motion for summary judgment.
May I return to my seat? Pray. Your Honor, if I could add something to that. The former lawsuit was in the District Court of Lee County of Alabama. It was regarding a charter bank account. I can't remember the last 4 digits. I've got them here, though, but it was a charter bank account. He claimed throughout that entire lawsuit that you feeling comfortable? that bank account was under the Alabama Uniform Transfer to Minors Act. If you contact Charter Bank, they will confirm that account is under the Georgia Uniform Transfer to Minors Act. So part of the motion for summary judgment is asking that because it's in Alabama. Also, there was a mediation agreement. That mediation agreement has been broken. There were supposed to be 16 equal payments starting in January of 2013, going through April of 2014. The account that he is alleging those payments came from closed in September of 2013. Therefore, I request access to that fiduciary account at Charter Bank.
Let me ask you, would it do any good to defer this to mediation?
No, sir. I've been sued before on these matters.
He's been sued one time.
And 6 of them, Your Honor, are outside the statute of limitations. We filed a detailed brief. We're here for argument today. My wife is stressed out by this. We'd like to be heard and have the court rule.
I also would like to be heard. I would not like to infringe upon the defendant's right to be heard, but I would like to highlight 16 years of legal experience, 0 years of legal experience.
Well, that's not our problem. We're here to say to the facts in the case.
Okay, I just want to make sure that I get a chance to counter any facts he brings up that may not be facts.
Okay, and you, John Paul.
Yes, sir.
Plaintiff. Okay.
Yes, Your Honor.
It's our motion, Your Honor.
What's your motion? Okay, well, go ahead.
All right, sir. If you, I guess if you look at his complaint on the second page, he listed 7 causes of action. And I'll just go through those with, we feel like summary judgment is appropriate.
Okay, then, 7 times.
It's on the second to last page of his complaint.
You said second to last page of the original complaint? Causes of action?
Defendant's joint motion for summary judgment, is that what we're about to do?
Yes.
What we're talking about? Okay, one session here called the synopsis, and in the next session, undisputed facts. Is that where we are?
That's my motion. If you look at his original complaint that was filed on
Has to approach
June 7th. It
bench.
begins-
So has to approach the bench. Just walk up to the bench. Your Honor, it's going to be the complaint that has Carroll County above a scratched out Coweta County.
That's it. This has Coweta County and Mark Flew and it's Carroll County up over there. So that's what we're talking about.
Yes.
Is that under the section that starts with allegations?
No, this would be the next one, causes of action, second to the last page.
Okay, guys.
All right, sir. All right, I'm gonna go down each one. The first one says, Wesley Schuster acted as custodian for an inheritance of the plaintiff and breached fiduciary duties owed to the plaintiff. My father passed away, and my two sisters were executors of the estate. We provided affidavits that state these facts. And it was my two sisters as executors that awarded each child the Uniform Transfer to Minor Act rights for their own individual children's. The plaintiff, in his reply on Exhibit 13, has attached a document that was filed with the probate court that shows that I was handed the money under the Alabama Uniform Transfer to Minors Act. Page 51 of my exhibits show the check I received on March 27th for $10,000. I deposited that check into an account, and I began to distribute money to my son, John.
Objection.
Okay, on what grounds?
Insufficient foundation.
Overrule the objection, go ahead.
Yes, sir, Judge, these are in my affidavit. If it's not, I will tell you. And let's see, my son was born on April 11th, 1993. That becomes relevant because Georgia and Alabama have different ages of majority. Georgia's 18, Alabama's 19. In June of 2012, John picked the form. He sued me in the District Court of Lee County, Alabama for this money under the trust. He was a resident of Alabama, in-state, attending Auburn University at the time. I appeared in court in December of 2012. We went to mediation. We entered an agreement. I abided by the terms of that agreement, paid an attorney's fee that he agreed to, and distributed all monies to him. I did not charge a fee or any money. All monies went to him.
False. I don't know how to sit here and
I had forgotten until I read the plaintiff's memorandum. On April 7th of 2014, my wife and I could not finance the house because my name was showing up related to this court case. So John and I filed a joint motion to clear the title. John signed an affidavit that he had no present, past, or future claims against me. For some reason, that document says the Georgia transfer to minors.
Let me ask you right quick. Who is John?
John, the plaintiff.
I'm John Paul Schuessler.
Yes.
I would just like to add that transaction did not meet the arm's length principle. As an experienced attorney, and I believe he was active with the Alabama Bar in 2012, he wrote the entire affidavit that I did sign. That is my signature on the affidavit, but he wrote the entire affidavit and the accompanying capital G, capital A, capital T, capital M, capital A acronym, whatever that may stand for.
Okay, go ahead.
So anyway, the court at that point dismissed all claims against me, individual with prejudice. And so it was in Alabama. We all probated in Alabama. Money was handed to me, designated as an Alabama Uniform Transfer to Minors Act.
Improperly.
When was that?
It was in March of 2012. And it's in my affidavit that I filed with the court. So we went to court, we entered an agreement. I paid the money under that agreement. And we had a file we refinanced in 2014, and we clarified that issue with the court. And John stated at that time he had no claims against me. At the time, we were paying for his apartment and trying to help him with school. So the first cause of action has been performed. It's outside of the statute of limitations.
That's false.
And we've already been to
Objection.
court. And we've been to the court on this issue in the district
In
court
your
of
statute of
Alabama because of
limitations.
his decision to sue me previously. We've settled that.
So what relief are you asking from the court today?
I want these charges dismissed because they're outside the statute of limitations. Two of them are due to dismiss because they're outside of the statute, and they are barred by res judicata.
Nope.
Okay, what are you asking?
For today, I'm not asking for a final settlement of the case. I'm not there yet. I need more information. I need information from that document. I would like to respond to the defendant's, Wesley Schuessler's affidavit, which he just referred to part of, or something similar that he had said in it a moment ago, but he did not clarify whether he deposited that $10,000 check into an Alabama or a Georgia account, which would greatly impact whether this court has the jurisdiction to hear this aspect of the case.
Did you deposit that check in an Alabama account or Georgia account?
It was Lynette, Georgia, which is on the line, but he's received the money.
Time out. There is no place called, there's a Lynette, Alabama, and there's a West Point, Georgia. Which one is it? Come on. Come on.
I don't think there is a Lynette, Georgia.
There's not.
Or Lynette, Alabama.
Okay.
Well, call Charter Bank, because Charter Bank is saying that it's a Georgia account. And there's a 10-year statute of limitations on Georgia fiduciaries, 9/3/27.
It was just, we reached out, I'm going to go on to the next cause of action.
You want to know?
I said, there's 7 more here.
He wants to bully his way through this. Nine 3/27, 10-year statute of limitations. OCGA 9/3/27, 10-year statute of limitations on fiduciaries.
Let me ask you, what are you asking today?
For today, one would be access to the Charter Bank records. It's a fiduciary account, so they won't let me have records. You gotta go through the court. 2, I don't know how to bring it up, but possible perjury. There are multiple statements of significant facts in the affidavit of Wesley Schuessler that aren't true, including the state that he deposited the $10,000, including dates that he began issuing the check. In his affidavit, he says things like how he would write checks and I would endorse them and cash them. That is totally false. I have records from a separate Charter Bank account that was my own personal checking account. On March 21st of 2012, I received a cash deposit of $125 in my account from Charter Bank location 58. Charter Bank location 58 is in Noonan, Georgia, and if you ask the defendant where he worked back in 2012, he will say, if I'm correct, East Coweta Middle School, which would make sense for Noonan. Now, he, under the guise of his own personal money, he pretended that he was paying me my inheritance, and the entire inheritance is an issue because he was never authorized under Alabama law to possess that money. So in my opinion, he brought $10,000 into the state of Georgia, and if you want to call it conversion, commingling, I don't know what you want to call it, but he was never authorized to have that $10,000. Under Alabama's Code 355A4, that is how Lila Schuessler was nominated in the will of my grandfather as custodian for all grandchildren or any successor custodian she may designate in writing. She never designated Wesley Schuessler as a successor custodian under Alabama 355A19. His entire possession of that $10,000 was illegal. Not only that, but he then deposited it into a Georgia bank account, which gives this court jurisdiction. And there's a 10-year statute of limitations on fiduciaries.
Okay, what about that?
Judge, we've got 2 lengthy affidavits with documents. The plaintiff sued me on this matter in Alabama. We reached an agreement.
He broke that agreement also.
That was mediated in the district court in December of 2012. I performed under the terms of that agreement. When we had to fix the credit problem so my wife can get out, he signed an affidavit saying he has no complaints against me. I've performed under this. I've already been to court in the state of Alabama on this matter because that's where he brought a lawsuit against me.
That's because I thought the inheritance was governed by the Alabama Transform to Minors Act, which I had never even heard of until his answer and motion to dismiss in that Lee County court case.
Judge, let me just add.
And he's never provided accounting for the account.
Let him answer.
Yes, sir.
We filed two motions today because in response to our motion for summary judgment with the affidavits, with the documents, he filed a two-page memorandum. So we filed a motion to strike his unsworn defendant's reply to our plaintiff's reply answer in his memorandum and any testimony he may offer today because no affidavits were filed before the close of business yesterday. So we're here because when a plaintiff doesn't file a response to motion for summary judgment, he waives the opportunity to present evidence and he can only come and argue the law. And we're here today to argue on the motion for summary judgment. That's what the court set it for.
I would call this bullying.
You were what?
I would call this the bullying part, where he's going to do stuff that I have no idea how to counter. But there are genuine issues to be disputed that reasonable minds could disagree on. That is what I'm here to say today. And I would also like to add that he has never provided accounting for the fiduciary account. He's never once provided accounting.
This has all been going on since about 2012, is that right?
1996.
1996.
He, in our affidavits and documents, his mother gave me physical custody in 2009 because she was having trouble with him, as stated in the documents you have. He came to live with me, and things went pretty well till the end of the senior year, when he became really difficult. And we tried at different times to have a relationship with him, but have been unable to deal with some troublesome behaviors we've documented in there. His second complaint against us is that we will not communicate with him, and he's claiming that it is negligently committing emotional distress because we won't talk to him. And we don't have a duty to talk to him, and he lays out allegations in paragraphs 19, 23, 25, 26, and 27, where we are ignoring him, and that causes him emotional distress. And there's not a duty on our part to speak to him, and he hasn't laid forth any evidence that would justify any sort of emotional distress for the state of the intended. So the second claim is due to be dismissed as well. His allegations 19, 23, 25, 26, and 27.
have any obligations to him that haven't been fulfilled?
No, sir.
Yes. It does. In our 2012 mediation agreement, I initially sued for $9,250. That was $89.50 of what I thought was my inheritance, plus $300 of filing fees for the District Court of Lee County. I came to that number by taking $10,000 for my initial inheritance and subtracting each $125 payment that he paid me. That would also prove, if you do the math on that, that will prove these payments that he was making to me in cash, just going to the bank and saying, I'm going to deposit cash into this account number, please, that I was including those payments because they make the amounts equal. If you take away a couple payments where he paid just cash and not out of my inheritance, the amounts aren't the right amount. In addition to that, he was supposed to pay the remaining balance minus $1,000 to his attorney for a fee, the remaining balance of $89.50 minus $1,000 divided by 16 for 16 months. He only paid for 9 months, and it wasn't even the correct amount once you do the math on it. So he does owe me an obligation to tell me where approximately 5,000 or so of my dollars are, if not more.
Okay, we're not going to go much further with this, but okay, go ahead and tell. Okay, what about that?
Judge, the evidence is in front of the court, and in my affidavit, I paid him all that money.
There's no receipts. There's 0 receipts.
And
You did no accounting. You never in your life have you provided me accounting. It's hard for me.
In 2014, we were done. That account closed because it's all.
No, the account closed in 2013. The account closed in September of 2013. That's why you're signed over there. It was supposed to be payments through April of 2014. The account closes in September of 2013. I am just now becoming aware of that in the last few weeks. And I'm urgently pressing Charter Bank to get as much info as I can, and they've told me until you go to court, you can't get any more info.
Judge's lawsuit was in 2012. We performed the agreement. You have that.
He broke the mediation agreement, which I have here if you'd like to see.
Anyway, Your Honor, we've.
No, you
oral
have.
arguments not required in Georgia. We have fully briefed this matter. We have a different.
He's bullying me. He's bullying me to avoid paying me thousands of dollars. He's using his law degree that he has and his experience in law to bully me right now. I grew up with this man bullying me for 20 plus years. He has done everything to me but sexual abuse. This man owes me money and will not discuss it.
We moved to strike all that. We filed a motion for summary judgment. He's filed his response.
Basic questions.
He didn't offer any facts or evidence. We're entitled to summary judgment.
No, you're not.
It's supported under the code. And an adverse party cannot just rest on his mere allegations or denials of his pleadings, but he has to respond by affidavits or otherwise. His complaints are primarily outside the statute of limitations. I think we fully.
Doctrine of contra non-volentum, equitable tolling, part 4. It's not really fair when you have 16 years of law experience and I'm a minor child during most of this. That's not really fair at all.
Judge, the final thing I'd add is the last time we.
There's nothing to keep you from hiring an attorney and having an attorney represent you.
Money.
Give you advice. Okay, I'm going to finalize this case right now by finding in favor of the defendant. Okay.
In favor of the defendant. See you in Alabama. It's garbage. It's garbage.
Your Honor, before he leaves, there was an amended complaint for a 2008 battery.
Yeah, there was a child abuse investigation that was opened that never. You lied. You said you were divorced. You got married on 3/23, and on 4/1 you said you were divorced.
The judge told you to be quiet, and be quiet when the judge tells you to be quiet.
Okay, what now?
Anyway, it's buried in his amended complaint in the middle of it, and we did file a motion to dismiss that as well. It's a 2008 complaint. It doesn't relate back to his original pleading.
Okay, dismiss that case, all cases that's pending.
So when he pulled me by the hair and hit my head against the window, we're dismissing that. Justice was not served here today in this
Okay, at any
case.
rate, court dismisses the case.
Justice was not served in this case. You're the most despicable human being I've ever met. You are just a
Hey.
fool.
You be quiet and wait the courtroom case is over.
I'm leaving. Don't touch me. Don't talk to me. Don't look at me. I'm sick. I'm sick. Who do you talk to?
Okay, if
Sir.
you would, you're gonna be
Leave
in
the
contempt
courtroom.
of court if you say anything else. You're going to jail. You understand that?
Yes, Your Honor.
Okay, so you might as well leave.